Do you want to read the
Certainly.
virtual meeting and rules of decorum?
Public participation at the Cannabis Licensing and Advisory Board meeting. The city is engaged with community members to co-create a vision for productive, meaningful, and inclusive civic conversations. This vision supports the physical and emotional safety for community members, staff, and board and commission members, as well as democracy for people of all ages, identities, lived experiences, and political perspectives. More about this vision on the project's community engagement process can be found at the link on your screen. The following are examples of rules of decorum found in the Boulder Revised Code and other guidelines that support this vision. These will be upheld during this meeting. All remarks and testimony shall be limited to matters related to city business. No participant shall make threats or use other forms of intimidation against any person. Obscenity, racial epithets, and other speech and behavior that disrupts or otherwise impedes the ability to conduct the meeting are prohibited. Participants are required to sign up to speak using the name they are commonly known by, and individuals must display their whole name before being allowed to speak online. Currently, only audio testimony is permitted online.
Okay.
I shall move on to member roll call. Member Anderson.
Gotten no response back.
Member Christie.
Present.
As previously noted, member Daniel will be absent today, as well as member Green. Vice Chair Keegan.
Present.
Chair Kunzman.
Present.
Member Noble.
Sorry about that. I'm present.
Ex officio member Thompson.
Present.
Ex officio member Bailey.
Present.
Chair Kunzman, we have a quorum.
Good, and we will, I'm hoping and assuming that everyone, all the four official members are going to be here for the whole meeting. I know Allison has to go at 6. Kate, you're good for the duration also?
True.
Excellent. All right, thank you. So let's take a look at the minutes from August 7th. Are there any comments, corrections? Not. I'll entertain a motion to approve.
Chair, I move to approve the minutes from last month.
And a second on that?
I'll second. Brian seconds.
Hand vote? All approved? Oh, Michael, can you can you stick a virtual hand up or? Or Michael? Let's see. Michael can hear us. See if he's having more problems.
Sorry, Tom.
It's okay.
I'm just trying to navigate through this. What do you need from me? You need me to approve the minutes?
Yeah.
I second the approval.
Oh, Brian did that. Evan, well, welcome. We're just approving the minutes from last meeting, August 7th, but I believe you were not here, so.
I don't believe I can approve the meetings from, or the minutes from last meeting.
No. Michael, do you approve the meeting minutes? Evan, will you be able to get a camera going for this meeting?
Yes, for a portion of it. I am in the
Okay.
vehicle. I'm in my vehicle right now, so
Okay.
I suppose it would probably be smarter for me to turn my video off, but I am physically present here.
Chairman, if it would be fine. I mean, we would have a quorum if Evan just abstained. He can be recognized as a vote. You would still have a majority vote approving the minutes. So
Evan, do you abstain?
I abstain.
perfect. Thank you.
All right. All right, now, general public comments for the board.
Certainly. Agenda item number 2, general public comments from the board. Public comment will be limited to 3 minutes per speaker. You can elect to speak by using the raise your hand function at the bottom or top of your screen, depending on your format. I don't see anyone calling in by phone. And I see one such individual. Let me pull up my 3-minute timer. Mr. Bat, are you able to hear us?
Yes, I am able to hear you. Can you
I
hear
will
me?
certainly, I will start your timer now.
All right. Well, thank you so much for the opportunity of these 3 minutes. Just wanted to say um, that I was curious if the new recommendations that Health and Human Services might be making about tax structuring, if that might make an impact on nonprofits starting up, because a nonprofit would be able to receive or profit companies would be able to receive tax benefits from donating to nonprofits. I don't know if that's a topic that could be put on the agenda or up for discussion. Because I am interested to see nonprofits come in up into the business just to help with education and all the wonderful things that nonprofits can do. And I won't take my 3 minutes, but I just wanted to commend you guys on your work. And just keep encouraging the nonprofits to come on board, because there was last time I remember there was a woman who had talked about her concerns about cannabis being in the hands of youngsters and being and abusing it. So nonprofits can come in and do the education, and they can receive the benefits by getting donations from the for-profit companies. All right, thank you.
Andy, do you want to comment at all about that, or have you been following have you been following the news, the HHS news?
I haven't. I'm happy to look into that a little bit more, but I have not.
I think some of us have read a little bit about it, but we're not experts. Anyone, Kate, or anyone feel confident in enlightening the rest of the board as to, it was from August 30th, the HHS has been talking about easing the restrictions or easing the.
Yeah.
Go ahead.
I was just going to say the talk of rescheduling from a Schedule 1 substance on the Controlled Substance Act, or controlled substances, to a Schedule 3. And so, it eased up some of the 280E tax restrictions for cannabis businesses. I don't know the implications that it would have for, nonprofit donations, but obviously if you are able to make exceptions in using, 280E exemptions, then obviously there will be more benefits to those businesses to be able to provide to nonprofits. So the assumption is probably yes, but again, that is just a recommendation from the first kind of organization that's come out and said something. We, hope to hear something in the coming months from the federal government about how they may want to proceed. Doesn't mean that we'll have an actual answer, but that's about all I know, unless there's something else that they were referring to. But that's been pretty much the hype.
Do you have a sense of the next steps, if there are next steps that might happen? Because it's right now it's just a HHS recommend. I don't even know if it's a recommendation yet.
Well, Biden had asked, for movement, right, on it earlier this year. So, I mean, I would be speculating with the hundreds and thousands of other people that are writing articles about which way it would go and what it would mean and what it could mean and what will the FDA do and what will the DEA do and what will this and that. I mean, it's, yeah, my opinion would just be that as an opinion. So, I mean, I think it's definitely interesting and worth kind of checking out some articles. There's some good ones out there that kind of show the pros and cons of, rescheduling versus descheduling. But I'll leave that to y'all. I'm happy to maybe put something in the agenda packet or the meeting packet for next time on a couple of articles that I think are valuable. But all in all, you're just going to get, wherever the money's coming in from whoever's talking, that's typically what, the direction that you're going to kind of hear.
And Tom, if I may just add, I believe that the DEA is receiving that recommendation from Health and Human Services, so then they will analyze it and then make the recommendation or the policy, I should say.
Okay, well, thanks for putting it on our radar.
All right, thank you so much, guys. Appreciate it.
Did anyone else on the board have any comments they wanted to? No. And I can't, Evan or Michael, I can't see you, so anything you want to say about that? Hey, Pam, I think you're up.
I think Evan was, I don't know if Evan was talking, but he turned his camera on.
Oh, okay, there. Sorry.
Not the first Health and Human Services recommendation for rescheduling. Won't be the last. Nothing will happen from it. And we do not want, recreational states do not want reclassification to Schedule 3. So hopefully it doesn't go anywhere. That's what I will say as a business owner.
Okay, thank you. All
Chair
right,
Kunzman, I'm not seeing anyone else for public comment.
okay. There's some notification at the top of our screen about a participant. You probably see the same thing I'm seeing. Has enabled captioning.
I do.
I can jump in. That just indicates that someone has turned on closed captioning. It doesn't affect the meeting.
Okay, thank you. Okay,
Continuing on, matters from the Cannabis Enforcement Officer, Officer Gignac.
Well, I guess it's good afternoon. So seized IDs have slowed down a little bit, but they're still above the average of the previous quarter. The trend now is that a lot of them are actually out of state folks that have come here to visit and decided to try and buy marijuana using a bad license. So I have been able to track down a few of those and give them their summons. Only 7 referrals to CU, Judicial Affairs. And other than that, it's been business as usual.
it's staying at a heightened level, but not accelerating.
No. There was just a big jump from April to May. And so now it is evened out, and at least it's not increasing anymore, so.
Is there a seasonality to,
No, because even the dispensaries were just shocked by it because it didn't coincide with the students being in town or not being in town. It was, hopefully it was just an anomaly that will go back to the lower numbers.
anyone have any, oh, Kate, sorry.
It's okay. Just a question about, do we know that they were actually out of state people, or whether the IDs were just out of state?
No, the
Fake
people
IDs.
were out of state because I was able to track them down through
Okay.
family members and actually talk to them. Some are students from out of the 10, like East Coast, a lot of them. But yeah, they were all out of staters visiting.
Got it. Thank you.
Mhm.
How far, Robin?
That's okay. I guess I just had a question about, was enforcement stepped up at all, or were there more, no? Okay.
No, just the, staff were catching them through the normal routine of checking the ID and watching for telltale signs of nervousness, and then and this is one advantage marijuana has over alcohol, is that there are those software programs you use, like IntelliCheck and other ones to verify if it's a valid ID. That really is of great use to this industry.
Thanks.
How far back do you have data? It goes back well before the pandemic.
I'm sorry, what was your question?
How far back do you have data? And does it go back well before the pandemic?
Yeah, it was interesting during the pandemic. There weren't that many licenses seized. So I don't know why it would, now that people don't have as much free time on their hand, you'd think it would be the other way around, but
Not me.
really.
Masks and plastic screens and visibility issues and lack of desire to look somebody really close in the face. If somebody's standing right in front of you right now, it teaches away. You can tell if that eye color or if to you, but if they're dropping a mask down for 3 chances of you actually identifying a fraudulent ID are significantly reduced. I did have a question for you though, Pam. Was all of that a result? Were all of the confiscated IDs a result of staff identification, or was any of it a part of operations by the city to identify fraudulent IDs, or was it just turnovers by the dispensaries?
Majority were turnovers, and just a handful were some ops that we were doing outside the businesses. So
Outside the businesses though, but not inside.
right, watching them when they actually first pull up into the parking lots, and they're making
Gotcha.
their little plans.
Enough said. Enough said. Understood. Thanks for doing that, by the way.
Yeah.
The old parking lot handoff.
Yeah.
Well, we have always fought to prevent those, but they're difficult to do. Cameras can't cover
Yeah.
everything. So.
Oh no, I mean but the industry really is doing a really good job. So
Good deal. Thank you.
Just so I understand, I mean, Evan clearly understands, but someone has a real ID, they go in with a real ID, and then they hand off to maybe
Yeah. Think of the underage kid asks the guy to go into the liquor store and buy him a beer.
I'm a six pack.
Okay.
And then he hangs out off camera in the back of the parking lot and walks outside.
Yeah.
That's been an issue forever. We've had many incidents of catching people doing that, but it's really difficult to completely eliminate. So knowing that the city police is aware of that and keeping eyes outside. I mean, we can't afford to staff people to hang out outside, and staring at cameras outside is practically impossible. So we identify it, we ban people for life, but the truth is it's impossible to truly eliminate that. So if you guys are doing it and you're being successful with it, that's great to hear. Thank you.
Okay. I think we're ready to move on. Do we have any policy suggestion forms?
We should have a hand from Kate here too.
Oh, sorry. I
It was just, I was just going to ask a question about the ID. Do you actually differentiate the fake IDs from the in possession of IDs separately? Do you track those differently? Or different trends?
Yeah, the main trend, the problem is fake IDs nowadays with technology. They are extremely hard if you're just looking at it to be able to say this is a fake versus this isn't. And like I said, the new trend is that they'll put their picture on an ID that is somebody else's information. And so like IntelliCheck, that process is having issues because it doesn't see the picture, it sees the information and goes, yep, that's real. And that's where the staff is catching it. So kudos for them. But it still floors me, going back to our time with the shoulder tapping for the alcohol, is how they just don't find somebody who's legal age and say, go buy me some marijuana. But they don't. They take the chance with these fake IDs.
Been happening for decades. At least in alcohol. Robin?
I guess this is kind of a question for both Pam and you, Evan, because we've seen these really drastic reductions in medical cards for people between the ages of 18 and 21, because those requirements were increased so much by that 2021 legislation. And what I'm wondering is, are you seeing more, fake IDs because you have this younger market that's still trying to gain access? I mean, I don't know if you have any way of knowing that, but I wondered if Evan had seen anything along those lines that he thought was interesting to share.
I think it's the intersection of the two forces, the fake IDs are easier to come by and medical gives you less benefit. So if you have a higher confidence in a fake ID that costs you the same amount as a doctor's prescription that doesn't get you as much product anymore, I mean, sad to say it, but 18 to 21-year-olds are conniving and careful and calculating when they are seeking to get what they want. And at the end of the day, they're going to, and the system is designed to try and alleviate it as much as possible. But as rapidly as we improve our reduction in availability, they improve their access to solutions that work for them and make it more difficult for us. I will say that what Pam is saying is definitely true. The quality of the fake ID from 10 years ago to today it's incomparable. I mean, you could tell from the texture of the laminate 10 years ago. These days, if you're not using blacklight, scan, microprint identification and magnification, you're basically not able to do it unless your staff can just tell. And I can tell you that the vast majority of our confiscations do not occur as a result of technology. They result as an event where somebody says, you're not presenting right, you're anxious, you can't answer very simple questions, what leads them to actually say, hey, I'm going to break out this grow thousands magnification or 100 times magnification and identify the microprint that's wrong on this. But that is something that's a couple minute process, and what's generally giving it away is people's demeanor and understanding of the counter. It used to be somebody handed you a fake Illinois ID, you could feel it and know in 2 seconds that it wasn't real. But that's not the case anymore. They are much, much more difficult to identify now. So it is, I think the accessibility of training for being able to identify this stuff is hugely important. And we had a big stretch of time where it was readily accessible and there was a lot of programs being advertised and businesses were able to capture them a little bit more easily, but that's reduced a little bit. But I think it's something we need to be promoting to all of our dispensaries, because if we're seeing reductions in total confiscations, that's probably because IDs are getting better and people are getting a little more lax. So.
Thanks, Evan. Pam, can you enlighten us? What are the current consequences for like a 16-year-old being caught with a fake ID, trying to sell or trying to buy cannabis?
Well, it's a misdemeanor. Criminal summons is issued.
So does it go on their record then, or not necessarily? Yeah. Okay. They go in front of a judge.
Yeah, it's a mandatory court appearance. They can't just pay their fine. So
The parent involved usually.
I'm sorry.
Is a parent involved usually then?
Well, only accidentally when I get hold of mom and dad and ask them if their child is named so-and-so and they were in Boulder on a certain date. And then I explain to them I need to talk to them about trying to use that fake ID to buy marijuana. Yeah, the majority, CU handles it their own way. I know they make them do a certain number of community service hours and attend some classes and things like that. And municipal court kind of does the same thing, makes them do some community service hours and a few other things. Or they can just, put their plea in of guilty and pay the fine assessed by the judge.
Thank you.
You're welcome.
So now, do we have any policy suggestion forms?
Policy suggestion forms, there were none received for the September meeting.
And then topic
Moving.
Go ahead.
Moving on to our next agenda item will be the discussion regarding the CLAB rules of procedure.
Are in the packet from pages 19 to 31, I believe.
Yes, however, there was an updated version emailed to all CLAB members and posted on the web with some additional edits.
And if the chair would like, I could share my screen to just walk through sort of the rules real quick, at least as they currently stand.
Sure. You want to share your screen?
Yeah. Let me just go. Oops. I think that's wrong one. Okay, you should be able to see this here now. Yeah, we circulated the draft rules. I think back we prepared a version that was discussed briefly in August, asked the members to get back to us with different revisions, and then we went through and integrated some of those additional revisions into this latest draft, which is part of your packet. I wanted to just sort of walk through the changes that have been made, but also if it suits the chair, just open it up to the members to, as we kind of go through this, if you have any other additional changes or comments, concerns, questions, just to open that up for discussion if that works, Tom.
Yeah, let's go for it.
Andy, could I just ask you to just increase the zoom on your document, lower right-hand corner to
Yeah.
150?
Yeah.
That's a lot
Is that
better. Thank
better?
you. Yeah.
I can even get a little bit more in. So these, as we've discussed, they're modeled off of the BLA rules. So they were in pretty good shape. We just had to adapt them a little bit for CLAB's unique circumstances. I don't think there's anything really worth discussing up here, but I did want to call out this new change. So this was actually suggested by Robin, which is just adding our mission statement here. And in fact, I'll just, are there any thoughts or concerns about having that mission statement included here? Okay. And so scrolling down, there was an error that was caught here by somebody. We got rid of this, including by way of limitation, by way of example and not limitation. So basically this just says now for incomplete applications, applicants must respond to all required applications questions and provide all required information, documents, plans, and details. We just didn't think it would be, I guess, appropriate or worthwhile to go through and enumerate all the instances in which there could be an incomplete application. So, I mean, they need to complete an application or risk having it rejected. So that was that change. We get down here, there's a couple words that some of the members recommended we put in, including just there were some capitalized words and things that we just uncapitalized. You'll see those changes here. Those are in your packet. Not too material. And then this is kind of a change that we wanted to call attention to just because it implicates the order in which things will be done for these applications. And so essentially, so notice of hearing. So the hearing shall be set following the city's receipt of complete application and all required application materials, the applicant receiving all permits and initial city approvals and all inspections performed. So we struck that because I think the staff wanted the ability to perform inspections to verify certain information is correct. Kristen, if you're on, if you want to elaborate on that, just so the CLAB has some context in terms of the timing of when this, kind of how this whole process will work.
Sure. So the reason why we removed this section is because staff would propose that we actually perform the inspections after the hearing. There's a couple reasons for that. Number one, it provides the opportunity for the board to make any recommended changes to the applicant prior to the inspection. And then number two, it allows us to do the inspections after we know a license has been approved. So we're not spending staff resources going out and doing these inspections if the license is going to be denied at hearing. So that's why we recommended removing that section, performing inspections after the hearing, which is also consistent with the way we do inspections for the Beverage Licensing Authority for new liquor licenses as well.
And so I think how this would work as a practical matter is your approval is going to be approving the license on the condition that it passes inspection. And if there's an issue with inspection, staff would need to bring that back for CLAB to reconsider the application if that works. So. Are there any questions, comments, or concerns with that? I know that's a little bit more substantive of a change, but we thought it was just important to direct your attention to it. So. Okay. So we'll keep moving. Again, some good catches. I don't even remember who this was that caught some of these sort of is versus are. Another good change here that somebody caught: energy impact offset fund versus the climate sustainability account. And then this is kind of another substantive change that this was actually another one of Robin's comments that we thought would be worth discussing. And I'll say this with kind of the caveat that I think there's going to be additional discussion that happens around these hearings and what they're like. And I think we're going to have a script developed that's similar to BLA's script that just helps us walk through the process of these hearings, because obviously these are quasi judicial hearings. So everything that's said is recorded on the record. Everything could ultimately be reviewed by a judge and could be important to understanding sort of the CLAB's decision making with respect to a given application. So this is all important, and I'll show, first of all, the section is this hearings, decisions, and appeals, and it's the section 6-1 rules of evidence. The statement, so there basically talks about admission of evidence. So the rules of privilege required by law shall be respected. In other words, attorney-client privilege. There's some other privileges that may be applicable. And the chair may exclude incompetent, unduly repetitious evidence. And then it goes on: questions concerning the competency of witnesses to testify on behalf of or in opposition to the issuance of the license, the materiality, relevancy, or competency of their testimony, and other evidentiary matters shall be determined by the chair. The chair shall rule upon questions of evidence and procedures subject to being overruled on motion sustained by a majority vote of the members present, of the CLAB present. So this is procedural, right? It's just setting forth the, basically saying, hey, there's going to be at least some application of the rules of evidence, and the chair makes these rulings on evidence. And so Robin's good point was essentially just asking, how often does the BLA chair determine that someone's testimony is not material, relevant, or competent? Besides the majority overruling the chair, is there any remedy for a board member if they believe the chair was wrong in keeping someone from testifying? And so we just thought this merited more discussion. So in quasi-judicial proceedings, and this includes even proceedings where people are appearing in front of what's called an administrative law judge, so somebody who's trained to rule on matters of evidence. There's a variety of rules and principles that basically say the rules of evidence are very liberally applied. So it's not like it's a district court proceeding where there's a district court judge that's stringently ruling on the rules of evidence to exclude testimony and exclude evidence and make evidentiary rulings. Ideally, the CLAB would be very liberal in its application of evidence. It would allow, the only two parties in these proceedings are the city and the persons who are applying and having their application reviewed. And so I would just really strongly encourage the CLAB as a board to just let people say their piece, present their evidence, present their testimony. I think the CLAB's approach should really be just allowing it to come in, considering it. And if it's something that you think is, well, it's hearsay, she's saying what this person told them and we haven't had an opportunity to this person, that's all fine. That all goes to the weight of the evidence. If it's some document that you're questioning how probative it really is, again, it goes to the weight of the evidence. I don't want to completely foreclose that we would, restrict evidence in some fashion, but I would just encourage the CLAB to just let it come in as evidence and have a discussion as to how probative and how much weight you give that specific evidence, whether it's somebody testifying, a document, whatever it is. Just have that discussion open on the record. That can help you all sort of formulate your own views and opinions. And that way we're not, sort of precluding people from coming into what's supposed to be a less formal presentation and proceeding. So that is a long way of saying exactly what we have here, what we've added here, which is setting expectations for the people that come and appear before the CLAB, while also giving the CLAB just sort of some wiggle room about this liberal interpretation, which is the Colorado rules of evidence are not applied stringently. Though the CLAB's membership changes, the CLAB generally consists of medical and industry professionals, not attorneys or judges. And therefore, the CLAB allows introduction of evidence liberally. Persons appearing before the CLAB are strongly encouraged to raise arguments concerning the deficiencies of evidence and testimony rather than attempting to formally object and obtain a ruling from the chair. So we're just kind of saying, you know, the chair's presiding over the proceeding, but we're not judges or lawyers here, at least most of us. And we're kind of setting that stage for, hey, come in, say your piece, present your argument, and let the CLAB consider it and weigh the evidence. So I know that was a long sort of tangent, but I thought that was important. And I don't know if anybody has any comments or concerns or questions, but just wanted to throw that out there. So
Robin, before you go on 1 second, Andy, just to echo what I heard you say, that in almost all situations, there's only going to be two parties testifying, the applicant and the city, and that would be city staff or the city lawyer, or who would be representing the city?
yeah, so it depends on the issue. It's potentially just the documents, like the CLAB reviewing the application materials and the actual like words on the page. I mean, that's submitted by the applicant themselves. Staff might have other documentation that they want to introduce that is pertinent. So I don't know what all that might be, but Kristen, I don't know if you want to speak on that in terms of what you guys usually see with BLA, but yeah.
Sure. So typically for BLA, we provide the application materials in the packet, so members will have the opportunity to review those prior to the hearing. And then for BLA, in the hearing itself, the applicant has an opportunity to present their application, share any details that they think the board should take into consideration. And staff is typically just available to answer any questions and just kind of support through the process. But staff typically doesn't present any testimony to BLA, typically.
I'm just trying to anticipate what I'm not even sure whether it could happen, but because the application includes what is it called, neighborhood, or is that neighborhood responsibility plan that includes details of the neighborhood outreach that has occurred. What if somebody from a neighborhood shows up at CLAB in opposition to a application?
So every public hearing for a new license application is going to be a public hearing. So there will be opportunity for members of the public to provide comment on the application. So we'll be noticing the hearing by publishing it in the newspaper. There will be a public notice poster posted on the licensed premises prior to the hearing. And then as part of the neighborhood responsibility plan, the applicant will be doing outreach and alerting neighbors to the fact that there's a public hearing as well. So there's a very good chance that you'll hear from neighbors during the public hearing, and that's all part of the process.
But that doesn't necessarily make them a party to the proceeding, if that makes sense. So if you all deny and there's an appeal, it's the city of Boulder that's the party to the proceeding that has to defend the board's decision making. So
Robert?
And thanks, Andy and Kristen. And Andy, when we talked about this particular point, on my first question, does this happen in the BLA often? I believe your answer was no. It doesn't happen that the chair says this person is not material and can't give evidence as part of the proceeding. So is that still, did I hear that right? And if so, I would just say that this language really satisfies what was on my mind, so.
Kristen's more familiar with the BLA, so I'll let her speak to that, but I would imagine it is, yeah, it would virtually almost never happen. I mean, there has to be some preservation of the decorum if somebody starts doing something so strange that just doesn't make sense. I can't predict what that might be, but so we do have these rules of evidence that are applied. But yeah, I would imagine it's hard for me to envision a situation where we would preclude somebody. But yeah, Kristen.
I would agree with that, Andy. This is not an issue that BLA deals with very often. It would be very unusual for them to have to deal with a situation like that.
You're muted, Tom.
Does anyone have any other questions about that part, or do you want to go on in?
I can keep going. Oh, I'm sorry.
Okay.
Member Thompson.
Yeah, sorry, it just popped up. Is this the language then, is that meant to replace the language that's there, or it's in addition to the language that's there, just to make sure that that's
It's an addition to the language that's there.
great.
Yeah.
Okay, thank you.
Great. And thank you, Robin, for that comment. So the next substantive change, so this section 6-4, this was actually, I think this might have been another Robin comment, but I know we discussed, Kristen and myself and Rewa discussed this a little bit. We decided to strike this last part. So this is obviously in the agreed upon conditions of approval. So the language previously said, and it still says, the CLAB may impose conditions of approval on any license, permit, or action when agreed upon by the applicant and other parties, provided the CLAB independently concurs with the proposed condition. And so this is another one that I think one of the obvious conditions would be that it passes inspection, but there could be other conditions where there's some uncertainty that the CLAB is still relatively, certain that something is the case, but it needs additional information. And so this is sort of, in my mind, it's sort of a stopgap where the CLAB can say, okay, applicant, we'll grant your application, but we need proof of this, or we need confirmation of this, and the applicant can go back and do it, and we're not required to hold like a separate hearing, or to deny and then just come back and do a separate hearing. We can kind of process that once they provide that proof. So that's this part. And then the second part is, which is now stricken, the CLAB may, separate from the agreed upon conditions, direct at any time that any license renewal will be changed to non-administrative approval, thus removing renewal from possible administrative approval. So we struck this just because the CLAB's authority, so the BLA's authority is much more involved with license renewal. The CLAB's authority under the Boulder Revised Code is pretty specific, that at least for now, it is for the issuance of denial of applications, and renewals are processed administratively. And so that was this striking. I hope I didn't inadvertently set expectations that you all would have a more involved annual renewal process. I think that's not supported by the BRC. At the time, I think when we had this language, I was originally thinking, well, maybe there's a chance that the CLAB could do a conditional approval that just wants to make sure the first year, for instance, goes well before it authorizes renewal. But even that, I just thought was too much of a stretch of the CLAB's authority under the BRC. And so that's why this section was stricken, and we wanted to call that out. So, and from a CLAB's time management perspective, that's probably a good thing as as the CLAB gets used to doing these hearings. But I'm sorry, Chair, you were going to say something.
Oh, no, I was gonna ask, see if anybody had any questions. Okay.
Oh,
Robin.
Thanks, Andy. I guess I had asked the question if there was a particular licensee that was running up against a lot of problems. Chris, when we talked, Kristen described sort of the administrative process for dealing with that. And I do understand why it is not going to be part of CLAB's responsibility to look at renewals. But it was worthwhile for me to hear how those kinds of issues are handled. And so, Kristen, I don't know if you can just briefly speak to that. It might be of interest to the CLAB. For instance, if there's, a problem with a particular licensee with an underage sale or any other sort of violation of their license.
Sure. So, any license violations or compliance issues, any kind of enforcement actions would be continued to be handled administratively by staff. So right now, we handle those administratively. We issue notices of violation, we issue fines and penalties when needed, and that will not be changing with this quasi judicial transition, since the board is only going to be reviewing new license applications. So Robin, I don't know if that's what you were looking for.
Yeah, I think so, Kristen. I just think, if there was any expectation, and I sort of partially did have this expectation that CLAB was going to be part of that process, but it's kind of clear that that's not our role.
yeah, and that goes to it's basically once you grant a license, I guess I would say the due process rights are heightened. And so if there's an enforcement action that's taken, that goes before the municipal court, where it's handled with, again, going back to the rules of evidence, where those are applied a little bit more stringently, and it's treated a little bit more like an adversarial court case where, the city is preparing evidence and everything else. So it's that was some additional context we had discussed, Robin, that the rest of the CLAB might benefit from knowing. So
Thanks very much.
and so continuances, I think this change maybe had been made prior to the last version, but in essence, I had tried to keep this door open in case we don't have a quorum at a hearing. That basically, so the BLA rules say just this first part, the hearing shall be continued. And I had thought, well, maybe we could, if we didn't have a hearing or a quorum, that if the applicant consents, we could still move forward with the hearing without a quorum. But we just decided, for a variety of reasons, that it really makes sense just to continue it if there is no quorum. Part of that is to ensure there's diverse perspectives, that we don't try to either push through decision making with only 3 persons attending. But anyway, so that's a change that we implemented, that we really just need to have the quorum, 4 voting members, and have diverse discussion, and hopefully have people who have prepared for the hearing enough that we can have sort of meaningful discussion about the matter. So decisions. So this is something that's worth hitting upon. So the CLAB will render its decision, and then in the background, I will work with staff and with Tom or with Brian or whomever else was the chair at the hearing to finalize a written decision that we actually deliver. And it's the written decision that it basically memorializes the findings of the CLAB, and it starts the clock for judicial review is when we issue that initial or that written decision. So wanted you to be aware of that period. But we basically extended the period in which that occurs to 60 days versus 30 days. I don't think we'll need 60 days. I'm hoping we can turn around these decisions pretty quickly, both as a courtesy to the applicant and just to keep things moving. But that was a change that we made. So, and that is pretty much all of the material changes. And sorry, Member Thompson.
Hey,
Yeah, I guess the question was, I watched the, like listened to the audio from the October BLA meeting, and they went through like a motion, right? A motion to approve or deny. Does this mean that that we don't do that in our hearing, and that this decision comes after, or this is the longer version, or the more detailed version is why the decision was made one way or the other?
Yeah, I wouldn't even say it's more detailed. You'll still do the motion. I mean, we still need a very clear record as to exactly what the decision was, what the voting was. We need discussion about the justification. So that's all still needed. The written decision is basically just a memorialization of what occurred. Yeah.
Thank you.
Yeah. And so unless the chair has anything else, that's the CLAB procedural rules. And in terms of process, I mean, I guess we should open it up for any additional changes now, but I think in terms of process moving forward, we would prefer to finalize an additional draft that's cleaned up and then have that available for a specific section of, Kristen, I can't remember if we said the October meeting or the November meeting for public comment, to have one last sort of opportunity for public comment following publication. And just but in my view, I think we're in good shape with the current draft rules, and we'd be curious about everybody else's thoughts.
So Andy or Kristen, on sections, especially 6.6 and 6.7, which are seem rather trivial, but I just wondered, does it ever come up in the BLA that time limits are imposed, and then does it ever come up that one needs to get a stenographic recorder?
Oh, go ahead, Kristen.
Oh, I was just going to say it's not common, especially the stenographic reporter. There may be instances if you have an application that's particularly controversial, if you have a large volume of comments, that might be something that you'll want to limit. Or if as the chair, you have someone presenting their application or their attorneys presenting the application, and you feel like it's going on for too long, like you do have the ability to set time limits. It's not something that we see very often, but this section gives you the ability to do that if you need to.
Yeah, now I'll add, I mean, the stenographic reporter, nobody will use that as long as the meeting's recorded. So as long as we have a video recording of the meeting with audio, anybody who wants to challenge us can go back and have that transcript prepared after the fact. And then the time limits, I think the big thing would be the cumulative evidence. So that could be a type of thing. I would guess that would only happen if it's a really contentious hearing where somebody just keeps repeating the same thing over and over again and is just stuck on something. Basically we don't have to continue and hear their argument over the same thing over and over and over again. So I agree with Kristen. I mean, I don't think you would ever need that, but I guess there is a risk of something becoming really contentious and just some attorney coming in and just harboring on one issue over and over and over again. And so, yeah.
Okay. Are there other comments or concerns about the rules of procedure? What, did you answer when are we thinking for Kristen? To put it out to public comment?
We'd love to include this in the October packet if the board is comfortable with the final version.
Well, we can take a vote. But any more discussion?
Not from the city attorney's office.
Not seeing any. Would you prefer a motion to have it October, or I'm seeing yeses around the virtual room. Do we need a vote?
I don't think we need to vote unless somebody actually is objecting. I think we can just add it for the agenda for the next meeting and go through the publication and take formal public comment during a section of the meeting for it to make sure there's a record created surrounding that, because we are adopting rules. So, but otherwise, I think we're good.
Okay. Any objections to putting it on the October meeting schedule? Okay, hearing none. So ruled.
Great, thank you.
Now I need to find the. Go ahead.
Continuing on in our agenda is matters from the city attorney.
Okay, I'm back on. The only item I had was just to remind, and I had actually shared it on the screen. Maybe I'll share it just real quick. The basis for board member attendance, and I wanted to hit on this because obviously a quorum is going to be really important when we start actually reviewing these applications. And it could, I'm not sure how heavily involved this process will be just yet, but there is a world in which people are worried about getting approved and they retain counsel and they prepare a case and they prepare witnesses and they're very organized and expend a lot of time and effort and resources into, getting a license. And that's where it would be a shame if CLAB members prepare and we go into a meeting and we realize we don't have a quorum. And so just out of respect for those participants, out of respect for the applicants, out of respect for the public, I wanted to show this portion of the Boulder Revised Code. It's 2-3-1. It's just the general provisions, and it's obviously there's the subpart A, the city council, and it's this, A2 may remove any member by a majority vote for conflict of interest, any other violation of applicable law, regulation or policy, non-attendance to duty, failure to attend 3 consecutive regularly scheduled meetings without leave of absence, approved by a majority of the board or commission, or any other cause. And so this is the key part. It's the city council can remove a member for failure to attend 3 consecutive meetings, and this is the standard. Consecutive regularly scheduled meetings without a leave of absence approved by the majority of the board or commission. So I hope we don't have to get to the point of having the CLAB members, I guess, consider that for a member. But that is the standard. If you're a member and you're not attending meetings for 3 consecutive times and you haven't obtained a leave of absence, that the CLAB could move forward with requesting that the city council removed you from membership as a part of the CLAB. And so, again, not trying to be, I guess, unduly negative about this. Obviously, you all are volunteers. Everybody's contributing valuable time. you're appreciated. This is an important role. So I don't mean to undermine any of that. I just want to reference that as we move forward as a board and as we undertake what could be a pretty consequential task for the city in terms of litigation and in terms of just sort of the board's overall role and prerogative within the city. So does anybody have any thoughts on that?
Well, the last, can you keep it up there for a second?
Oh, yep. If I can.
If you can find it again.
Yeah.
Okay, so the last clause or the last two lines of section 2, we don't, as a habit, approve someone's leave of absence. We don't vote on that. Is that what it's implying? That, like, should we have a part in our agenda where we decide whether somebody's absence is approved or not?
I don't know that you need to go there, but I think it's, I would suggest you all do the reverse, where if there are 3 consecutive regularly scheduled meetings where somebody does not attend, that the board have that discussion, whether their absence was approved, and maybe request that they discuss what happened with those with not attending. So and that this is, I mean, it's ultimately up to you all how you want to treat this. I think we owe it to the public to regularly attend unless there's a valid reason for us not, and to communicate that and make sure the board's on okay with that. So
Awesome.
I was just interpreting that leave of absence as something like if someone was going to be traveling for a few months, or if they had a family medical thing or something, that you could say, hey, listen, I'm not going to be here for the next couple months, and then have that be an agreement that that would be outside of, that would be approved outside of the bounds of this missing 3 meetings in a row. I do think it makes sense to maybe have as a practice, not necessarily in this, but just as a practice, that maybe after 2 in a row that the chair reaches out, or maybe there's a conversation. I think to Andy's point, it's unlikely that it would get to this point, but maybe that's something we can do as a just sort of a practice versus a written policy.
Do we want to put it in writing, what you just suggested?
I don't think that's necessary. I just think it might be something to think about.
Okay. Others? We still have, okay, all right. Still have 5 members, right? I mean, this is already part of the city code. It's already approved. There's nothing to approve.
right, yeah, it's already part of the code. It's applicable to all boards. And I see member Noble has hand raised.
Oh, sorry, I'm down on the bottom of the screen here now. Okay.
Thanks. I mean, I think what I'm hearing you say, Andy, is if you're on this board, we're taking on a stepped up responsibility. There's people who are running businesses, who are spending money, time, staff resources, hopes, etc. And there needs to be some reasonable assurance that there'll be a quorum. And I don't think that's an unreasonable thing. And I don't think it would be unreasonable for our group to make a group decision about, maybe it's a process for, if you're going to be absent, some sort of notice or some sort of way of reaching out and making that clear I think that's really reasonable, and I don't see you providing this as any sort of thread of being left off the board, but what I'm hearing, I think, is, you know, if you're gonna do this, we have to have a reasonable expectation that people are going to show up and that there's gonna be a quorum. And that seems really reasonable to me, and, you know, I think we could have some sort of agreement, and maybe, Chair, you can explain how people let you know that they're not going to be at the meeting right now, and how much time people are giving you for that. I know sometimes you start the meeting and you start off by calling people or texting people to see where they're going to be and that sort of thing. No complaints here whatsoever, for those sorts of things, but when you have somebody who's coming forward to try to get their license approved, that's a very different thing.
Well, you're right in the sense that it's highly variable. And sometimes it goes to staff. Sometimes I'm CC'd. Sometimes we find out the day of or the day before. And then, as you notice, sometimes I'm texting people at the time of the meeting too. I mean, the more advance notice, obviously, the better. But
well, Kristen Teague and Kristen, I mean, do you guys have a suggestion? Is there another board that lets you know about attendance? Any ideas?
I can. So with Beverage Licensing Authority, they, with as much notice as possible, those authority members email licensing online, our main licensing online email address usually, and then whoever the BLA clerk is, and then the chair of that board as soon as possible. And that's the procedure that they tend to usually follow. Because it would be ultimately, if there's not a quorum to be held, there's certain things that kind of need to be done as well.
Has that been reasonably effective for that board?
Mm-hmm.
Yeah.
They're very diligent about it if and when there are absences.
Okay.
And it's a smaller board too. Right.
Mm-hmm.
5. Less room for absences. Okay.
That's all I got, Chair. So thank you for letting me post that.
I have put my agenda somewhere else on my screen now. Regulatory Licensing Office?
Yes. The next item on our agenda is matters from the Regulatory Licensing Office. Licensing Manager Changaris.
Thanks, Kristen. So I just had a couple of scheduling things I wanted to mention. First, wanted to talk a little bit about a board retreat. We've been kicking around this idea the past few meetings. Staff would like to propose that we schedule an in-person board retreat on Monday, November 6th, in lieu of the regularly scheduled CLAB meeting. We think this would be a good option for a few reasons. Number one, we don't have any other pressing matters scheduled for November, so it seems like a good opportunity. Number two, it would give us some time to do some training before we transition to quasi-judicial in January. And then number three, we've spoken to the cannabis inspection team, and they've confirmed that they are available to attend that meeting and provide a presentation on inspections and answer any questions about that process. So it just seems like, at least from a staff perspective, that's a really good opportunity to schedule the retreat. So I just wanted to put out that proposal and then open it up to the board for discussion.
November 6th.
Yes.
All right. Questions? Conflicts? Concerns? Where would it be roughly? Do we know?
Yes, it would be at the Brenton building, which is where our licensing office is. It's right at 11th and or Broadway and Alpine. So we can send instructions for parking and how to access the building. But it's right next to like the Hungry Toad.
I love that proposal. It sounds like a great use of retreat time and of all of us being together in person.
Anyone have concerns or conflicts? Do we know whether Ethan or Stacy have we asked them? Do you remember whether they sent anything?
We have not reached out to any board members yet. I'm happy to send them emails individually to see what their availability is, if the board would like to move forward with that date.
And would it be hybrid?
No, it would be completely in person, just like our last retreat.
Kate, you're still going to be in Michigan, I assume?
Yeah, I'll do what I can and see what I can do, but I can't guarantee anything at this moment, but I'll let you know as soon as I know for sure whether I'll be able to be there.
Is it possible to have a hybrid option for someone who's out of state?
I don't think that that's necessary. I think it should be in person and not be distracted between two different methods of communication. I think if I can't make it, then that's okay. If I can make it, that'd be great to see everybody in person. But like I said, I'll know in the next couple of weeks whether that's something I can swing.
I'm in a lot of meetings that it seems like most people are now in person, but yet, you know, 1 or 2 or 3 are still virtual for whatever reason. Might be a health reason or something like that. It seems the city council, do they have that option? I mean, I've noticed with the election forums that they're allowing those options.
I believe so, yes. I believe city council does do hybrid meetings.
Is the Brenton building set up for that? Or is it?
It could be set up for a hybrid meeting. We just really felt like an in-person, once a year in-person meeting would be really beneficial. And it also provides like a good opportunity for board members to ask questions and receive feedback in a more like personal, more comfortable setting. Andy, did you want to elaborate on that at all?
I don't think so. I think we were just wanting to encourage everybody to attend in person. I see Rewa just raised her hand, so yeah.
Rewa?
Well, I just wanted to respond to Tom's question. Does council allow hybrid meetings? Council has 2 council meetings and 2 study sessions a month. Both study sessions are virtual meetings. Council meetings are in person with a hybrid option if necessary. Just to let you know, council does allow its members to attend for any reason if they're out of the country, on vacation, if they're sick, you know, if their children are ill or anything like that, then a council member will have the option to attend hybrid, and that council members to give notice.
Kate, I hear what you're saying, but I value your input.
Thanks, Tom. Appreciate that. Well, I guess there was, I looked through, you know, obviously I haven't been at the last couple of meetings, which I apologize for. And there was a conversation about hybrid meetings. Like this is a retreat. This feels very different to me than the meetings, but I guess, you know, I listened to the footage from the last couple of meetings. I did not listen to all of it. I did skip from different topics. So just in terms of, I know I saw that October would be a potentially in-person meeting or hybrid. Maybe you're getting to that. But I figured I'd just ask about meetings, but I don't want to like distract from this conversation about the retreat specifically in November 6th.
Well, that's a good question, though. Let's take a quick aside. And what is the plan for meetings?
So that kind of depends on the way the conversation goes for the November retreat. As of right now, we do have a hybrid meeting scheduled for October. We were going to check in with the board if you do schedule an in-person retreat in November to see if you still want to have that hybrid meeting in October, or if you wanted to have a virtual meeting in October and then the in-person meeting in November. But right now we do have a hybrid meeting tentatively scheduled for October.
Others? Michael, Evan, Brian? Robin?
I'm happy with the retreat on the 6th in person, and I would like the October meeting to be virtual. That would be my preference.
Yeah, second, formally Robin's statement. Yeah, I also like the idea of the retreat in person on 6th. It would be great to have Kate there in person. If you can't be there in person, then I don't think we need to bend over backwards. Sorry, Kate. And then for the October meeting, yeah, I'm fine with that being virtual.
Yeah, I agree with that as well.
Michael?
Tom, I'm fine with both of those dates and the arrangement. And I do like the idea of us getting back together in person if we can make it happen.
So Evan, back to you. I just want to make sure I understood. October, yay or nay on virtual versus in person?
October virtual, and then in person for November.
Okay. Allison, do you want to weigh in?
I think November in person and then flexible on the 2nd.
On the October. Okay. Well, I see 3 definite intentions to stay virtual in October. Okay. Which makes a majority. I don't think we need to vote. All right, and then do we need to decide now whether the forum for the November meeting? I mean, the options for the November meeting? I assume the city's not going to pay for Kate's plane flight, right? Get her gas money.
Kate, if you do come to Boulder, we'll make sure you get a box lunch.
Oh wow. Wow, that seems worth it.
It's about as much as our budget can allow. Sorry.
And everyone else gets one too.
They do.
And coffee. Some kind of box coffee. Okay, all right. Is there anything more on that issue?
Thank you very much. So we'll move forward with scheduling the in-person retreat on November 6th, and then we'll plan on a virtual meeting in October. And that's all that I had. I think Kristen Teague has a couple matters to discuss as well.
So the next item under matters from the regulatory licensing is board submitted articles. So what we've been working on is trying to find a way to streamline the packet while still providing as much information and detail that board members provide by virtue of the articles that they submit. One of the things that we had initially thought was to provide a sheet with the links. However, as we're finding out, some of those articles are behind paywalls. which don't allow for anyone other than the individual that's providing it to us access to it unless it's printed out. So with that being said, the solution that city attorney and staff have come up with to propose is that the CLAB member submitting the article provide no more a written summary of no more than 1 page with a link to the article at the bottom of that document to be included with the board packets. It would allow that a summary, and then anybody else that wanted to attempt to either access the article, or if it's behind the paywall, do what's required to achieve access to those would be the process going forward.
Okay, so not for this packet, obviously.
No, not for the packet that we just sent out, no.
Okay.
And I only have 1 article submission so far for October, and that came from Vice Chair Keegan. And I see Andy's hand raised.
Andy?
Yeah, Kristen, and that's just for paywall articles, right? That they have a summary, or is that for
No,
all?
we need to have it consistent across the board. It's too
Okay.
difficult for staff. I'm not gonna say it's too difficult. It's extremely difficult for staff to try and figure out which ones are and which ones aren't. So we need to just apply it uniformly, would be our preference.
But they would provide the link also.
Yeah. And then if whoever's wanting to access that link, they would be responsible for accessing that content on their own.
Okay, Robin?
I was just going to say, so when I get to an article that's got a paywall, you can just right click on that article and print it as a PDF. On almost every system will allow you to do that. And then we can share with the staff the PDF. And that's really, for me, an easier way to get around it versus asking board members to summarize and then provide a link and then hope people will pay for a subscription to Washington Post, for instance.
Sure. And while we do understand that might be a streamlined way, number one, we're looking at the volume, the sheer volume that we receive of documents that go into an electronic packet. So we're looking at space and the ability to do those types of things, but also with us accessing items that aren't, that we really technically don't have access to in a paywall format, that kind of stretches it a little bit. Andy might be able to speak to that a little bit more than more articulately than I can, or Kristen Changaris.
Yeah, and I don't know that I can, just because I think the license terms are all for those paywalled articles. They're obviously paywalled for a reason, so I don't know what our rights would be to distribute those internally into the public and how much we're sort of unleashing those articles. So it's like a very, very, very small likelihood of that ever becoming an issue, but that's one of the issues we discussed. So
I definitely can appreciate the extra burden that we're putting on staff when we send that. I know we send a lot of stuff your way to include, and we appreciate all your work to do that. And I think I agree that we should probably come up with a different way that works for everybody.
Mm-hmm.
My concern with having the person who's submitting it write a summary and then potentially, if there's a paywall, not be able to access that article is that if that's their interpretation, we obviously deal with things where there's a lot of different perspectives, at times a very contentious issue, that I worry that the person submitting it, that there would be more of their own opinion and their interpretation versus when, for example, when Brian's been able to share some scientific articles, that we can also look at that ourselves. And I hear you that we would have that option with a paywall. I think with the scientific articles, that's a little bit different than maybe the Washington Post one, just because that paywall tends to be a little bit higher. So I don't really have a solution to offer with, with my comments, but I think I have a little bit of hesitation with the written summary being the only way that some people might be able to access it. Though I do think a written summary regardless is a really good idea, because I think it is a lot that will mean the bar of what we send to you is something that's really important versus something that we just think is interesting. So I think that I love that idea. I just worry about the paywall piece.
Can I just quickly follow up and just say, I agree with you, Allison. I think a summary is not a bad idea, but, and maybe Andy, you could look into this, but in terms of the paywall, you're talking about a very limited distribution. Yes, it goes into the packet that goes to the public, but generally speaking, articles are shared. There's no commercial interest. It's kind of a fair use sort of idea in my mind. And if we could do, I like an idea of a paragraph summary with an attachment of a PDF. And I just wondered how Kristen, how that sits, how that maybe feels.
Andy, do you have a response first?
I don't, in terms of the legality. I mean, I think I still have the copyright and licensing concern, but I mean, one of the things, Robin, that the city's going through right now, that's kind of a major effort, is related to accessibility. And essentially on July 1st, there's an accessibility law kicking in that requires that governments make, for instance, all of their PDFs 100% accessible. And I won't get into the standards, but it basically means that they're persons who have, for instance, visual impairment can access and make full use of things that are posted online by government. And so the city, there's a tremendous cost to going through and making documents accessible. So I only say that, that's not to say that should be the factor that says we don't make this. Like, there's resource issues. Like, that's a whole can of worms that, Kristen's C&T can address, but I know there is some concern about liability associated with posting a lot of documents that we haven't made 100% accessible, and that we're trying to we're still working that out. But anyway, that's a long way of saying there's that additional concern that CLAB should be aware of as we go through this. So sorry, Kristen, did you want to add something?
Well, the good thing about the scientific studies is that there's usually an abstract. So you could just, one suggesting a scientific article could just copy the abstract or summary.
Yeah, just speaking on my own kind of behalf, like as someone who does try to sort of filter, I set up like Google Scholar alerts for like when there's new research that comes out about cannabis and marijuana and things like that. I do like filter through those and skim through those, and I try to just send you like the cream of the crop out of those. It is, I recognize the very real constraints that staff are under from both their own sort of time, the ways they're pulled in different directions, as well as sort of if there are new kinds of rules coming in, like accessibility Andy was alluding to. My intention was still nevertheless to like have these be papers that could be, through a fair use claim, to be something that could be read into like the public record, be available to the public, even if no one reads these packets. So yeah, it does feel a little bit chilling. I don't mean this in like a litigious way, but it does feel a little bit chilling that I won't be able to share as much, but I will still make an effort to summarize and try to make a slide deck or something perhaps. But
it sounds like from whoever first presented it, it sounded like it was a done decision, right?
No, we're trying something. we've realized that the paywall thing, just by providing the links, that's not the most efficient nor perhaps safe way to do those for risk, in addition to the requirements that are coming down the pike. So we're looking at trying to find a better way. And the better way that staff is proposing is a summary with the link where someone can then access it on their own if they did so desire.
Evan, you're on mute.
Yeah, the question of impartiality in the summary is incredibly concerning to me. I think that's a very difficult one. I also think the reality of accessibility concerns in the way, I mean, as an individual, I think the best idea is Robin's. I think print it to a PDF and share it so that we can all have access to the same information. In the case that we do that, yes, we have access and copyright questions, but it doesn't impact the accessibility modifications the city has to do. Whether it's behind a paywall or not, it's still a PDF that needs to be made accessible. So I recognize everybody's argument here. I think the simplest solution, the one that provides the most information to all of the audience, would be print to PDF on anything behind a paywall and provide the identical accessibility modifications as necessary, regardless of whether it's a free PDF or one that came from behind a paywall. So I don't know exactly what the best solution is here, but I think everybody's got a good argument. I think at the end of the day, the city's position is probably going to have to remain. It's not legal for us to copy something off of or from behind a paywall and distribute it to the public. And so I don't know that there's a super functional or super valuable solution I can offer here, but I hear what everybody's saying. I find myself compelled to agree with Robin on this one, but so it goes. I know for certain I don't want to read an individual's summary of an article. That's not valuable to me. But especially if it's going to alert me to something I want to be reading behind a paywall I'm not willing to pay for. So I'd much prefer to just have the PDF accessible to me. For whatever that's worth. Sorry, I'm trying to cook dinner for my family. My wife is out of town, so that's why I've been off camera this entire time. But so it goes. I'm here. I'm listening.
I've been musing to myself about if someone wrote a letter to the editor or summarized the CLAB proceedings from 1 month and put it in the Daily Camera, and those paywalls seem to be time limited or time determined. It's like on the first day, maybe you can access the whole paper and then it goes into a paywall. I think, I don't know, because I don't pay for the Daily Camera. But it would be weird for someone to summarize someone else's summary of our CLAB meeting, which, that's something that has come up several times. I don't know. I don't have the answer either. Are there legal concerns about sharing PDFs? Have there been precedents for people being sued for that?
I mean, the legal risk is probably very, very small, right? But you are taking something that when you sign up for a license, you're purchasing the license on your own behalf of an individual. And then if we're just distributing that content, we're subverting the intent of the paywall. So it's like, is it feasible that we could get sued? Yes. Is it much more likely that if somebody were concerned about something, which, again, as Evan alluded to, I mean, the city's position is we can't circulate copyrighted material that infringes on somebody's copyright. I think there's a question as to whether you as individuals can make that decision. But you know, that wasn't the biggest reason why this got percolated up. And so I guess I will say with Evan's comment about accessibility, I think there's some surprising nuance with the accessibility. There can be things like, is the color scheme appropriate where somebody can visually read it? And like some of that stuff that it actually, it's not like just clicking a button to make something accessible. It's like there's there's some nuance associated with that. And I don't know all of it. I don't pretend to know all of it. I just know that that's out there. And that's one of the considerations that's coming into play with some of this. So
Oh, I'm sure it's far more nuanced than I'm aware of. I'm simply getting at the fact that if it's from a free source and you print a PDF and share it versus being behind a paywall and you print a PDF and share it, they're both going to implicate the same complexities that we need to address for accessibility issues. So unless of course, every resource is applying the same accessibility standards, which I would imagine they are not. So.
Right.
Yeah, my suggestion here as a path forward would be maybe is there an option where we can distribute PDFs to each other as a private group as a board so that we sort of maybe are not running afoul of either copyright or accessibility concerns, but are still something that we as a board can read, circulate, and respond to, and then those could be made available to the public as links to the things that were distributed to the board to fulfill our obligations for public notice and meetings. So that's a question to staff. Can we have a channel where the PDFs go that don't have to fulfill the accessibility requirements, but we as a board can read and then still notice the public that these were the things that was shared in the board packet but aren't publicly available?
Andy, you had your hand up.
yeah, I would just, if it's a communication between you all, that's between 3 or more board members, it needs to be public. So that's the restriction we need to be mindful of. And I think what you were getting at, Brian, as well, you know, we would still announce it or announce that it was shared, or this is the document that was shared. I think that's fine. I think the question the public's going to have is, well, why, if the board members didn't have access to it and are sharing it, why can't the public have access to it and share it? Which as you, I'm sure, recognize, Brian, it's just, I get what you're trying to do with figure out a solution. So.
We have to make a decision on this today. Was this intended for next meeting? A change of affairs.
No, we can go ahead and maybe revisit. As of right now, we only have one article. I'm not sure if it is a paywall article yet or not.
That probably is, but I will pilot submitting my slides or summary. When do you need that by, staff?
With this being a little bit shorter, the deadline for packet submissions for October is on, one moment, let me get my calendar open here. Monday, the 18th.
I will try my best.
Okay. All right. There's not much more. Okay.
I only have one more item for this section, and that is agenda topics for future CLAB meetings. Right now, we have for the month of October, coordination with Alana Malone for discussion on concentrates.
Okay. Is there still what page is the list on right now? Of the packet.
The packet list.
It's on page 10.
Mm-hmm. Thank you.
Uh-huh. Can we put check marks on the things that we already, oh, presented to slash discuss, sorry.
I had a request or a question, if the rest of the board agrees. But Colorado Marijuana Enforcement Division is going through rulemaking right now. And they will likely have some things that they will want to change at the state level. And curious whether staff can plan on or would plan on doing any kind of presentation of what those things are, either in, you know, when they're done, December, January, February, or a way that we can more formally discuss rulemaking at the state level. I know it's in here already. It says legislative rulemaking and updates, but just thinking about, you know, either December or January is usually when they come out with new rules. And if there's a process that we can have staff kind of give an overview of what they saw, or if that would have to be like 3 months later, or just wanted to ask that.
Right? Or do you want to answer that, staff, first?
So just to make sure I'm hearing correctly, you would be interested in hearing staff interpretation, a presentation on MED after their rulemaking legislative sessions?
Yeah, or have, you know, the MED do a, you know, we've had them come before just to give a summary of what the changes were. Just want to put it on the radar, right? That this is the time of year that that happens. It'd be better if they could do it, obviously. But just wanted to say, like, this is the time that that happens, and when we could put it on an agenda would be great.
Okay, Brian?
One thing I would just add to this list, again, it doesn't need to be for October. I would just remain curious or would want to get an update from staff about SB 23290, natural medicine regulation legalization. Again, I recognize that the scope of our boards is defined by statute to concern only cannabis, but as there are other natural medicines come online, if there's any movement from city council to expand our board scope, or for us, for other kinds of medicines to be considered by our board as well.
Andy?
Yeah, that Brian, after you, I guess, commented about that originally, we have been investigating, and kind of the wheels are turning to get a grasp of some of the complexity surrounding some of that. So I can't speak to any action by like city council or whether that's under consideration, but I do think CLAB will be hearing more about this in the future. So
that sounds suitably vague.
I know. Yeah, I think that's all I can say at this point about that, but so that is on the radar, Brian.
All right, thank you for the update, Andy. Is there a timeline when, I imagine probably after council retreat in January would probably be the next time we might hear about something like this?
I don't know that it's tied to council. It's honestly just tied to internal workloads and discussions, and so yeah.
I would make mention that we are now down to 4 members. So if Mr. Christie has to fall off for any reason, we would not have a quorum.
Okay.
One thing I'll mention about the Natural Medicine Act that we've been kind of following at the staff level is the state rulemaking. The state will begin their rulemaking session in the beginning of next year, and their plan is to have the state rules finalized by May. So I'm not expecting any new information, probably at least for the licensing team, until the state finalizes those rules and we get a better sense of what the state licensing program is going to look like.
Well, that's helpful. Then maybe we could just say June 24, perhaps we could have an update or request an update from it's the state agency that's doing this. It's to have an update from the state agency that's engaged in the rulemaking.
Yeah, I think that would be feasible.
And
The
I do,
Department of Revenue. Sorry, go ahead, Andy.
well, I do think that's actually the med. I was just speaking to the attorney yesterday who represents the med with the Colorado AG's office, and he was saying that that's fallen within that group as well. So I'm sure we can figure out something or report. And back to Kate's comment too, I mean, reporting on the rulemaking and updates and stuff, that's totally fine. I'm happy to report on rule changes and things like that, or tee that up for discussion as needed. So including natural medicine. So
Brian, do you want to mention the listening sessions that you shared with me?
Oh, I think we talked about this in a previous session, but I think back earlier, maybe it was last fall 2022. Tom and I had attended a meeting at Naropa University, which has a psychedelic kind of therapy initiative. I'm probably getting that name wrong. I apologize. To hear from both the proponents of the larger ballot initiative, and then that was before the legislative session had started. So this legislative session is closed, the bill passed, and I think we're now in rulemaking. But I think that pausing on this until the rulemaking closes, we'll have greater clarity on whether there's an appetite for City Council to change our board scope, what those rules are, how that implicates our other kinds of regulations, like from the MED and so on.
I guess I meant the ones from the Colorado Department of Revenue's Natural Medicine Division's listening sessions.
Oh, I haven't been following those at all, sorry.
Oh, there was one this past week that I didn't know about until after it was over, or I didn't open that email. And there's other topic related sessions coming up 4 more times in the next 5 weeks. I could send this email. This email came from you, didn't it, Brian?
Yeah, it did. I forwarded that, but I haven't attended any of them now.
Okay. Andy, would you want to have that? Okay.
Sure.
Send it to you. You can share with staff, whoever's interested. Okay. Any other suggestions for future topics? Do we need to pencil in more specifically what we were even thinking about with Jonathan Singer, or I've lost that page, but Tristan Watkins or MADD. We don't have a topic. Although I guess we didn't have a topic for Cinnamon Bidwell either. But is Jonathan Singer working on something that I don't know about?
I think Jonathan, through the chamber, was very focused on social consumption, and I'm not sure, but beyond that.
And then Tristan Watkins is just leading social equity efforts in the governor's office.
Okay. Somebody.
The one, the impairment experts bullet at the top, and I wondered if Allison had anything from the report that you attached was really long and detailed. Was there an idea or a speaker or a conversation that you thought might come out of that, Allison?
Not specifically. I can give it some more thought if there was a speaker. It was more just connected to, I know we'd had a lot of conversation around those issues or an impairment, and so wanted to share the updated information with the board, but didn't have a specific idea of what's next, but I can certainly give that some thought.
Okay.
Kate?
Was that?
Yeah, just in terms of just in kind of the progress of the hearings. I know that in the BLA and Kristen, you kind of mentioned this too, but there's like and Andy, you did well, the hearing procedures outline in the preliminary findings report and report those things. I mean, obviously we're getting the rules of procedure kind of finalized in the next month or so. But obviously those things would be things that we would potentially want to see before we started the hearings in January. So just wanted to put that on the radar for a meeting in the next few months, or the training at the retreat, or whatever it is. But just wanted to acknowledge that that was something I was interested in, that I like to see in the packet, and thought that it would be good for us to see before things start.
Yeah, good comment, Kate. And we are working, and you will see that before we actually start hearing. So
Cool, thanks.
Okay. So is the only other agenda item the last agenda item?
That is correct. Matters from the chair and members of the board.
I have nothing to, I mean, I thought about the article that I submitted. I thought about, in a virtual world, one could get a professor from Johns Hopkins, but I have not proceeded in that direction. So, Brian.
Well, I just wanted to thank the board for your renomination and electing me again as vice chair. I apologize for missing last meeting. Couldn't even vote for myself or thank you in person, but I wanted to take this time to thank you all and acknowledge your trust. Hope to continue to act in your best interest of the board and all of its members, the public. So thank you.
Thank you for serving. All right. Any other comments from other members of the board in terms of articles or items of interest? Okay, are we actually done? Wow. Write this down.
I need a motion in order to do that.
Okay, all right. I'm entertaining a motion to adjourn.
Brian Keegan motions to adjourn.
And anybody second that? Michael's back on. Oh, Michael is on.
Second the motion.
Michael's got it. Okay. Any, do we need to have a hand vote on that? No, I'll just decide. Okay, thank you. And they're probably not all going to be this quick. But maybe. It was a weird day here, Kate. It was like, felt like winter in the morning. Almost. So.
Okay.
Sorry, I missed it.
Yeah.
You're just trying to extend the meeting, Tom.
Yeah. Okay.
All right. We are adjourned as of 5:07 p.m.
Thank you, staff. Thank you, members.
thank you.
Everybody.
Bye.
Thank you, everybody.
Excellent.
Bye.